Welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, as always, Canada's leading employee-side employment law firm. A couple items of housekeeping before we get started. As usual, if you want to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, as you see on the screen, and 1-855-821-5900. Okay, we're getting a little bit of a later start this morning, but please get your questions in. I want to get to them all if I can before the end of the broadcast, so please send them in as soon as possible so I can answer them as they come in. Okay, I'm not going to use this person's name because it'll identify them. My case has been going on for 2 years and did not get approval, waiting for an independent medical examination. What am I going to lose if I go back to work? Modified. I'm being represented by legal, which doesn't seem to be on my side. Listen, you seem to have a lawyer, and I'm going to refer you back to your lawyer. It sounds like you have a complicated situation involving a medical injury. I don't know if it has to do with your employer won't let you back at work if it won't provide you the accommodations you're looking for, and there's a need to understand what those injuries are, and then whether or not they go to the heart of the employment relationship. I'll say for everyone else, in general, medical cases are amongst the most complicated in employment law. They come up most often where someone injures them. Someone has an injury, could be at work or not at work, but they have an injury. Let's just say they work in a construction yard, and as part of their job, they have to be able to lift 60 pounds. They have a back injury, and now they can only lift 20 pounds. And so the question becomes, is that reduction in capacity to only 20 pounds from 60 pounds, is in fact that the injury, and is it permanent? And if it's not permanent, how long is it going to last? If it is permanent, does it go to the core of the employment relationship? And if it goes to the employee's duties, so if the employee has to lift 60 pounds continually throughout his or her job duties, then the employer can plausibly say, well, through no fault of our own, the relationship of employment or the contract of employment has been frustrated, i.e. extinguished, such that we don't owe you any obligations. We don't owe you a job. We don't owe you severance. We don't owe you anything because you can't do the heart of the job. However, if actually, this individual lifts 60 pounds a couple times a week and he gets someone else to help with that, then arguably it doesn't go to the heart of the relationship, and therefore frustration is off the table for the employer, and they have to accommodate the employee. And if they don't, it can be a termination or a constructive termination of his or her employment. So those cases are very complicated. I'll just say in general, if anyone's asking me questions on here who already has legal counsel, I would refer you back to your legal counsel so that that lawyer can provide you with advice as to your legal position. So I'll leave it at that. Question from Jeff. I received a very positive review this year, but my employer has now placed me under investigation and suspension without giving me reason or explanation. They want me to go off-site location to complete the investigation. Can I refuse to answer questions until they explain what's going on? I've seen this more and more so if there's an allegation that can lead to a termination for just cause, and I'll back up here for a second. Your only legal right in the event of your termination without cause is notice. So a heads up, you're going to be terminated at some point in the future, and the amount is determined by what your contract says, and then your age, length of service, and position, potentially. Or if they terminate you today, severance, i.e. money without having to work out a notice period. So they can fire you upon providing notice or severance, unless the employer has just cause to terminate your employment. Just cause just simply means a legally justifiable reason to fire you and pay you zero. Okay, so it's it's the law doesn't want that, because then you're thrown out in the street with no money and no job. And so the bar for that is very high. The employer has to prove to a high standard that it had just cause to terminate your employment. But certainly there are lots of things that qualify, such as, you could, if you came into work high on drugs, or you were intoxicated, or you stole, or you committed fraud or sexual assault, or criminal conviction outside of work, like all these things can lead to a just cause termination. Generally, they come in primarily two forms: the progressive discipline of the classic 3 written warnings and you're out, and it's more complicated than that, but just to generalize, or a single incident that is so egregious that the relationship of trust has been between the employee and employer has been destroyed forever by the actions of the employee. And even lying can get you there, about if you're lying about certain things or certain big things, or on an ongoing basis. But I've seen this more and more, where there's an incident and there's an investigation, but the employer doesn't tell you what the investigation is about. Never heard of it, saying, well, we want you to go somewhere else to deal with the investigation. So my first question to you, Jeff, would be, are they paying you? Are you on suspension with pay or without pay? If it's without pay, I would talk to a lawyer immediately, and like today. I talked to an employment lawyer today, and I would claim, or I would ask that lawyer about potentially pursuing a constructive dismissal, depending on what your employment contract says, on the basis of the employer's not permitted to suspend you without pay, and by stopping paying you, it has effectively terminated you, and then pursue severance remedies that way, depending again what your contract says, because maybe you don't have the ability to pursue lucrative enough severance remedies in that fashion, but based on what your contract says. But I don't know what it is that you did, or they allege that you did, but if you do it that way, it takes off the table any allegations of just cause, because you beat them to it, right? They suspended you, you claim constructive dismissal. Now all their allegations of cause later on they're too late. Okay, so I would if that's what's going on, I would talk to an employment lawyer today if you've been suspended without pay. If you've been suspended with pay, that's not open to you. Now the question is, should you or should you not cooperate in investigation? Well, if you don't cooperate in investigation, that can be that can harm you in any sort of just cause termination later on, because you were uncooperative. However, the real issue in a just cause termination is if you're dishonest. So what I see time and again is where an employee did something, and there's an investigation, and the employee then changed his or her story through the investigation, and the employer fired that employee for cause, and the primary driver of it was not, in fact, the legal peg that the employer was hanging its just cause hat on was not actually the act of the employee, but the lying, right, or the changing of the story, implying a lie. And so I would say in any investigation, it's very important that you are answering questions honestly and truthfully through the process. Part of the reason why they might not be telling you is because it deprives you of the opportunity to prepare for what your story is going to be under the accusation. They'll just tell it to you, and you have to answer, and it's more likely that you're either going to tell the truth, or if you don't tell the truth, it'll be easier to catch you in a lie later, because you have no idea what this is about, right? And so that might be why they're doing it. I would probably talk to a lawyer immediately. If you're unionized, talk to your union rep. But if you're not unionized, I would talk to a lawyer immediately. It's pretty substantial. It's worth it. You don't know very much, but again, if you're not on paid suspension, I'd consider strongly the constructive dismissal strategy that I outlined. And if you are on paid suspension, I would imagine you're going to need to cooperate. And I would just say, make sure you're honest throughout the investigatory process. And I would certainly keep asking them, what's this about? But I don't think you have a lot of options if they suspended you with pay. Nonetheless, I think you should talk to a lawyer right away. And if you want to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. One moment. Okay. Next question. My doctor requested that I be moved to a different role to accommodate my mental health. My employer has asked me to apply for these roles and isn't guaranteeing my position at all. Is there anything I can do? Okay, so you have a mental health issue, challenge. I don't know if it precludes you from working in your existing job. If it precludes you from working in your existing job, you can be on medical leave. You can pursue medical EI and or if have the insurance for it, long-term disability. Does your employer have a duty to accommodate under the Human Rights Code or whatever the human rights legislation is in your province? Does your employer have a duty to accommodate your disability by trying to put you in a reasonably similar role? I mean, it has the duty to accommodate your disability to the point of undue hardship, but I can't do my job writ large because of mental health issues. Maybe more likely that it is undue hardship. You're asking, well, why can't they just guarantee me another job? It's a good question. I don't know, maybe they don't want to. Is that a violation of their duty to accommodate by not just straight up giving you another job? I don't think it is. And I think that you have no choice but to cooperate. And, if you were to have some sort of claim later for discrimination or severance, the fact that you didn't apply for these jobs would, I think, probably be fatal to your case because you have an obligation to look for replacement employment to mitigate your losses. And if there's another job that pays you substantially the same at the company that you can do that you didn't apply for, I think that would be fatal to your claim. So I think you do have to apply for those jobs. It's not clear to me why the job you're in you can't do, but those other jobs you can do. Given that it's a mental health issue, I don't know. It might be it's with a supervisor or something. But I think the real question is, okay, if you don't get one of those other jobs and you're forced to stay in your position, what happens? Your doctor said it was like, did your doctor give you a note saying this individual, you can't work in this job anymore? Or is it'd be better for your mental health if you moved, right? So I think the real question is what happens for you medically if you don't get the job? Are you just unable to work in that position? And then what does that look like? Do you have the option to go on disability, et cetera? So, but I as I say a lot on this program, the best solution here is going to be an amicable one with your employer. I'd apply, I'd talk to my employer and say, hey, like, I'd really like to stay working here. Is there any way you could put me in this other position? What do I need to do to get the job? You have the inside track, right? Well, theoretically, maybe they don't want you anymore, but because of this incident, sometimes some employers look at medical stuff very strangely. They look at it as a problem and they want to solve the problem by having the employee move on. And others don't. Others are quite accommodating. So, and I certainly don't know which is the case here, but I don't know if this is only internal applicants, but if it's external applicants you're competing against, in some ways you have an advantage because you can talk to everyone directly. But, your employer can't guarantee the role. Is that discrimination? No, I don't think so. They're offering you the opportunity to apply for another role, but I don't know what your doctor's note says. Does it say it would be better for you to work in a different role? Does it say you can't work in your existing role? And if it says you can't work in your existing role, does it have an obligation to put you in a new role that's substantially similar? Depends on the nature of why you can't work in the existing role, and how different the roles are, and whether or not your mental health probably goes to the heart of the relationship, because it's the structure of your being at work, we'll say. But that's a difficult one. I don't have a definitive answer for you, but I would say it's not discrimination, and that you probably should apply for that job. Because if you don't, you're going to be seen to have, and if there's any dismissal later, or you bring a human rights complaint, that's going to come up as to why you didn't do that under your mitigation obligations, and there's no, well, if it comes to a termination, why didn't you do that? And you don't really have a good answer for that, other than you don't like that it wasn't guaranteed. So I would apply for it, and continue to see if they put you in the position, there's no issue here. But your question is complicated enough, and I don't have enough information about it, that I would recommend that you talk to a lawyer. I know I've said that a number of times so far on the broadcast, but I think you should. It's a little too complicated to answer in one paragraph. So again, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900 if you want to talk to us. Okay, question from Renee. If you're a dependent contractor fighting for severance in a wrongful dismissal that was paid 100% commission, can the company demand that your earnings are based on your tax returns? Sorry, I don't understand your question. Okay. So when you have 100% commissions, your earnings are going to be variable. So I don't think the question is. So there's this individual, Renee, asked about dependent contractor. There's three types of working relationships: employee, dependent contractor, and independent contractor. Employees are entitled to severance upon termination, and they have other things, CPP, EI, and so forth. Independent contractors are not entitled to severance on termination. Dependent contractors are, but they have different rules. Okay, and the test between whether or not you're an independent, you want to be an employee for the purposes of getting severance. Sometimes it's fine to be dependent contractor, and you don't want to be an independent contractor, generally speaking, in any sort of breach of contract situation for arising from termination. The test for which one you are, it's multifactorial and it's complicated, but it really comes down to, who are you working for? Are you working for yourself, or are you working for the business? Because, anecdotally, I would say a majority of, in quotes, independent contractors are probably employees. That's what I've seen. They're taking their marching orders from the employer. Their schedule is controlled by the employer. They don't work for anybody else. It's just, for all parties, it made more financial sense to structure it as an independent contractor relationship. But really, in fact, they are an employee, and the courts will treat them as such. And the primary result of that is that they're entitled to severance as an employee. So that's the first part of Renee's question. I don't think it matters for what his actual question is. So his question is, I was paid 100% commission, and he's asking, can the company demand that your earnings are based on your tax returns? Okay. So when you have variable compensation in a severance claim, the courts can do three things. They can say, we're going to look at the evidence for what you were making this year, and we're going to project that out. And maybe you have sales coming down the pipeline, and we're going to project that out over the severance period. Let's just say your severance period is 12 months. We're going to project, based on the existing evidence, what you're going to get over the next 12 months. So that's certainly one way to do it. Courts can also say, you know what, Renee, you made $100,000 last year. We say that means over the next 12 months, you'll make $100,000. We're just going to use your last year's T4. They can also, and this is probably what will happen in your case, but certainly I can't guarantee that because I don't know what the evidence is on the ground. The court can also look at an average of your last 3 to 5 years. Okay, and particularly if you're long service, if you're 35-year employee, they're going to do that, and or most likely they're going to do that. And they'll look at an average of your last 3 to 5 years, and they can come up with an average number, right? But if there's a trend, so maybe your sales commissions are going down, or maybe they're going up in terms of numbers, they'll follow the trend, right? It's just the court looking at its crystal ball and doing its best to project what you would have made over the next 12 months. Quite often, it's based on the average of your previous history. Now, if you're looking at a previous history and there's an outlier year, like maybe you made $100,000, $100,000, $20,000, $100,000, $100,000 over the last 5 years, the court will throw out that $20,000 year. They're not gonna look at it and just aggregate it and average it out. Generally, I mean, I can't speak for the court, but generally, and there's law in that, though the court will look past that one outlier a year. But if there's trends, certainly they'll follow it. And what happens a lot with salespeople, and you have to be careful about this, is there's an ongoing, never-ending battle between business owners and commission sales staff, and that's where the commission sales staff bring in business for the business, and they want to maximize their earnings, and the business owners. I mean, I'm generalizing. This is not always the case, but I've seen it hundreds and hundreds of times over the years, both as a lawyer and career in business before, where there's a drive or a desire on the part of the business to reduce the amount of commissions that the employee gets, the salesperson gets. And if there's been a change, like so over the last 5 years, you've made $100,000 in commissions each year, but now because of a change to the commission structure or your commission territory or whatever it is, your $100,000 is going to go down to $60,000. While the court can look at the average, because of the change, most likely you're only going to make $60,000, and the court will go with that, right? And so if you are faced with that in a situation like that, you may want to claim constructive dismissal. It's tough, right? If you're making big commission, I've seen it over and over again where someone's making huge money in commission and it's reduced, but through the reduction, it's substantial, like a 30% reduction, but they're still making more money than they can make anywhere else. And so they don't claim constructive dismissal, and then it gets reduced further later on, and it's sort of a death by 1,000 cuts situation. But if that happens to you and it's reduced, your commission is reduced, you have 2 months effectively to claim a constructive dismissal, triggering your severance, your termination, and then severance. And you may want to do that because if you accept through deemed acceptance by continuing to work without objection or under the new terms, or you just explicitly accept the reduction in your commission structure, you're stuck with that forever, right? Or at least you're stuck with that as far as severance is concerned down the road, right? So any future severance will be at 60%, not 100%, or 60,000, not 100,000 in the example I was giving you. So, it's tough when that happens, and it happens all the time. I misspoke when I said hundreds and hundreds of times, but I've seen it many times in terms of the what appears to be a continual battle between business owners and salespeople with respect to compensation through commission, because salespeople tend to be amongst the most well-compensated people at any company because they bring in new business, and that compensation quite often happens through commission. So to answer your question, yes, they can demand that your earnings are based on tax returns. Well, they can argue that, and they might be successful in it, because if you've got 15 years of commissions, why not use a 5-year average to figure out roughly what you're probably going to be projected to make next year? But the short answer to your question is it could be based on the evidence of what your sales were going to be this year, your T4 from last year, what you made last year, or an average of 3 to 5 years. And it can be all of those things in terms of projecting variable earnings. Okay, next question. Can an employer let you go after 4 years of employment stating that you need more qualifications or certifications to do the same job? are they allowed to do this, change this whenever? Listen, an employer can fire you for whatever it wants as long as it's not violative of the law. So specifically, it's not discrimination. So beyond that, like, they can't fire you. They can't say, well, I'm firing you because of your ethnicity. But they can say, we just don't like you anymore, so we're firing you. Or we've decided to change your qualification requirements, we're firing you. Strange, but businesses are entitled to do that, provided they provide you with the right amount of notice or severance. And if they don't, you have a claim of wrongful dismissal. Okay, so it's odd. I've never heard of that before, but certainly that's their prerogative. They want to get rid of you because now you don't have the right qualifications. They can. They just have to pay you the right amount or provide you the right amount of notice for doing so. Okay. Wayne, I was recently let go after declining a position change from my employer. When I was offered the change, I was not informed that my current position would no longer be available and was instead let go after I declined. My ROE states that I declined a different role, but this doesn't seem fair. Is there anything I can do? I didn't quit my job. You didn't quit your job. You were fired. So you have a wrongful dismissal claim. The question is, have you failed to? So you have an obligation to mitigate your losses by looking for a placement employment. And if your employer offers you a substantially similar job at substantially similar pay, and you don't take it, you have failed to mitigate. However, they offered you the job before you were terminated, not after. And had you known you were going to be terminated, you would have taken the job. So I think you have a severance claim. I think you need to talk to a lawyer right away. You should call us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. If you're in BC, that does sound like a fascinating claim you have there, and I'd be happy to talk to you. I don't know if the moderator can put my contact information on the screen. There you go, top left. If you're in BC, please feel free to reach out to me, because that is I've never seen that before. It's a fascinating fact pattern, but I would be happy to talk to you about that. Okay, so Sammy asks, would Canadian employment laws protect us from something like happening in the US, i.e. to write a letter and justify your position to a stranger? So this is a hypothetical question based on, I would assume, some of the job cuts that are happening in the United States that are in response to a letter. I'm really not quite sure, but the short answer is Canadian employment law does not protect you from. No, let me rephrase that. Canadian employment law primarily kicks in to protect you insofar as providing you notice and/or severance, usually severance, money rights upon termination. That's what it does. Okay, and so if there are more people terminated as a result of tariffs, for example, sorry, I'm just trying to turn this off. If there are more people terminated because of economic hardship caused by tariffs, the employer generally should not be relieved of its obligations to provide severance. Now, there is a precedent for contradicting what I'm saying, which is during the pandemic, we shut down the economy. The Canada's provinces elected primarily, I think all of them did, to shut down the economy in brief in March 2020. And when we did that, the business community placed everyone on a temporary layoff. And the temporary layoffs are ended by operation of statute after a certain period of time, which arguably would trigger a termination. It certainly would for employment standards purposes, and maybe would even do so for purposes of common law severance assessment. But regardless, the employment relationship comes to an end under the statute, the employment standard statute, and so the province in BC, all provinces were, they dealt with it in different ways, but certainly in BC, we're faced with all these employees after 13 weeks just being fired automatically by operation of statute. The employees didn't want that. The employers didn't want that. And so different provinces came up with different solutions. What we in BC did is we extended the statutory layoff period two times, and then all the way up to, it went from March 20th to August 30th. And then after that, automatic terminations would occur unless there were special variances provided by the province to continue the employees on layoff, because they all wanted to maintain their jobs. And why I'm saying that is, if I don't think this would happen, but certainly the provinces may have the ability, if there was a significant enough economic fallout from tariffs being imposed on Canadians, that they could do something like that again, where businesses lay off their employees and then they're placed on temporary layoff. They're placed on temporary layoff, hoping that there's a resolution, business picks up as normal. And so I could see a situation where some provinces could step in and again extend the temporary layoff period to allow businesses and employees to retain their positions for longer without triggering a termination, on the hope that the leaders of the two countries figure out a way to solve the tariff question such that the businesses can rehire their employees. So I could see that happening. That is just speculation. As it stands now, though, financial hardship does not relieve a business of its obligations to its severance obligations to employees. I don't know if question or not, but because I didn't understand your question, but I think that's what it was. So we'll just leave it at that for now. And unfortunately, we're out of time. We got one more question, and I'm not going to be able to answer it because we're out of time. So join us next week. We'll get it on the screen here. Join us next week. There you go. March 3rd, 1:30 p.m. Chris Justice. This new questioner came in. I'll call him Synergy. Ask the question on Monday, 1:30 p.m. Eastern time with Chris Justice. He'll be happy to answer your question. Other than that, thank you all for joining us. One last thing, if you want to reach us, because I mentioned to a number of people, you should do so. Reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Have a wonderful and safe weekend, everybody, and I'll see you back here in 2 weeks. But join us on Monday with Chris Justice. Thank you. Have a wonderful weekend.